All right. It looks like we are just past 10 o'clock. Still have some people trickling in, so I'll give it another 15, 20 seconds or so, and then we'll start off on this presentation. All right, let's get this show on the road. So, welcome. Thank you for everyone for being here. This is the Oregon Realtors January 2024 updates, the forms updates. My name is Nicholas Peasley. I'm one of the staff attorneys at Oregon Realtors. I help draft the forms and also help do most of the updates. So, I am going to give you the presentation, the skinny, on what has changed and what is being brought in, what's new. So, just kind of background, starting in February 2023, Oregon Realtors did release the forms. That was in mid-February. That was after a 2-year period of drafting it, as well as a 4-month soft launch. We released the first information about the forms in October of 22, and then for 4 months we sort of got feedback and made updates based on feedback during that October through February period. From February 2023 until April or so of 2023, we were doing these kind of drip updates. We were updating things as comments came back in. In mid-April, we decided we were going to do updates as kind of one single bunch periodically. So we're hopefully going to do 2 updates per year, one in the early part of the year, one in the later part of the year. Our second round of updates for that first version of the launch happened in August of 2023. That was the updates. If you did the training back in August, we did updates on various parts of the forums. We made some changes, not huge changes, but there were some. And then that leads to where we are now, where we're in January 2024. We are updating the forms again. We're adding some new stuff. We're making some changes. There are several new forms that have been added to the library. They are mostly just for quality of life purposes. Most of the forms, like the new forms, what they actually end up doing is just giving a piece of paper where something was previously done through a general addendum or with a personally drafted agreement between the parties. Case in point, for example, a referral agreement. We have a form now for brokerage to brokerage referrals. You've done that previously. It's not like referrals weren't happening before the form, but now there's something that hopefully helps provide some structure and kind of a scaffold for that process. And so most of the new forms, they don't actually change the process at all. It's just adding something, some structure to something that's already being done. It's worth noting, there is some change in the landscape for buyer compensation that's a result of the Sitzer Burnett lawsuits. Based on those lawsuits, there are some modifications that are being done to the way that we talk about compensation, the way that we address compensation in the forms, and the way that, for example, listings and buyer representation agreements refer to compensation itself and like how compensation is done. We'll cover that with more depth, I promise. I will point out instances throughout this training where there is a change, like the legal change to the forms. Otherwise, if I don't tell you this has legal impact, just be aware it's probably something that's mostly kind of aesthetic or it's done for quality of life purposes. It's not something that's the result of a lawsuit. It's not something where it's like someone got sued and therefore we're changing this provision. It's in most cases the changes are someone saying, you know, it would be really convenient if we had this thing here, and we make the change based on that need for convenience. There is also a form clause library. We will cover that with a little more depth as we go. The form clause library is going to be on the Oregon Realtors website. It is a tool that's designed to assist with the drafting of language that you use in general addendums and on those additional provisions sections that kind of fill in the blank part. This clause library itself is not actually a form. It's more something that just produces copy and pastable language. We'll get to it with more depth at the end of this presentation. So we'll talk about the clause library itself. But those are kind of the 4 base points of the updates, the summary. From there, we're going to start with the documents. We'll go in numerical order through the way that we organize our documents from 0 all the way up to the 9s. And this document 0 is our numbering list. It's basically the table of contents. That was updated as well because there are some new forms. This is where we'll talk about all the new ones. We added form 2.23, which is an acknowledgement of the receipt of documents. So we'll cover that. I'll pull that document up much more in depth as we go through the training, but that has been added, a way to acknowledge that you have received documents that you were supposed to get. We have Form 2.24, which is a seller's payment to buyer's broker addendum. We'll cover that with a lot of depth. We'll talk about exactly what that does and kind of how that works, but just be aware the form has been added. Form 4.2a is the statement of explanation. It's 4.2a when it has the little like number A. That's an attachment to the original document. So 4.2 is the investment property addendum. 4.2A is a statement of explanation. Periodically, you'll have an investment property addendum that says, give me 6 years of tax documents. I need to see the last 6 years of taxes associated with this property, because if I'm going to be making an investment, I want to make sure that, there's no lingering tax debts, or that the taxes are paid up, or that the taxes are what I expect them to be. And if the party doesn't, for example, the seller has only owned the property for 4 years, they're not going to have 6 years worth of tax documents. And so the statement of explanation is the way that they can say, hey, I don't actually have 6 years worth of documents. Please see this following addendum. And it will explain things. We'll get to it more in depth as well. Form 9.10 is a buyer broker compensation agreement. This is the BACs, the buyer broker compensation that comes from the seller's brokerage. There's a form to address kind of the compensation agreement between the brokerages. This has been done without an agreement in the past, but we're just putting a document in place that kind of explains how it works between the parties. Same thing with a broker referral agreement 9.11. People have been doing referrals for quite some time now, but now we have a form that basically says, in writing on a piece of paper, here is the agreement between the two brokerages. I am sending you a client. When you buy a house with that client, I will get a portion of that $50 or whatever it ends up being that you get as a referral for sending the client to the other brokerage. And we put it in writing so that you actually have some sort of a document to rely on if it ever does come to blows in a dispute. From there, we'll start with Form 1.1. This is the first substantial change that we'll point out. 1.1 is the residential purchase and sale agreement. It's the one that the kind of the bread and butter document that you will always be using. There's a modification specifically to the financial terms section, which is section 4 on the first page. Normally, this is the one that talks about what's the purchase price, what's the earnest money, what's the remainder of the down payment, and so on and so forth. 4E in each of the documents, or in most of the purchase and sale agreements, is the buyer's closing costs and prepaid items that will be paid by the seller in a certain amount. And then we've added this 4F and 4G. 4F is, does the seller's closing costs in section 4E include payment of the buyer broker's commission? Is the seller individually paying the buyer's broker commission in any way? If the answer is yes, then check that box and Form 2.24 is attached. If the answer is no, then don't worry about it. And then 4G is, if yes to the previous answer, we're going to specify the amount. If yes, seller is paying the buyer's brokerage compensation in an amount equal to a certain percentage of the purchase price or a certain amount, then you'll put that down and it'll basically be established in the purchase and sale agreement rather than in Form 2.24. That is the change to Form 1.1. That was the only change that happened to the residential purchase and sale agreement. We will cover Form 2.24 with more depth later in the training, but just for now, be aware it's a form that's used to earmark the seller side payments of the buyer's closing costs so that that money gets specifically used to pay buyer broker compensation. The same change, or similar rather, change was made to 1.2, which is the commercial purchase and sale agreement, because 4E in the commercial purchase and sale agreement does not refer to seller paying buyer closing cost. Instead, it's X amount of money is going towards personal property, see the bill of sale. Instead, 4F and 4G are now in reference kind of abstractly to the seller paying buyer brokerage compensation. It's the same concept, just slightly different language because the form is slightly different. On 1.3, the manufactured and floating home purchase and sale agreement, literally the same change as for the residential purchase and sale agreement. Does the seller's closing costs in the section include payment of the buyer broker compensation? If yes, attach form. If no, don't worry. If yes to the previous answer, how much are you paying from seller side over to the buyer brokerage compensation? Again, same change to the agricultural residential purchase and sale agreement. Does the seller's closing costs in section 4E include payment of the buyer brokerage compensation? If yes, then answer. If no, proceed. If yes, the seller is paying buyer broker compensation in an amount equal to a certain percentage. Oh, I'm sorry. Someone's asking if I can slow down. I will slow down. I apologize. Yeah, so this section is, we will cover with more depth what this means to attach Form 2.24, but for all intents and purposes, it is just saying seller is going to provide a certain amount of money to the buyer side as like to pay off buyer's closing costs. And we are earmarking that seller payment so that it must be used, or it will be used, on a buyer's brokerage compensation. It will be used by the buyer to pay the buyer's agent, or rather the seller will earmark that money so that it then gets utilized on the buyer broker compensation. 4G, depending on the commentary we get back from people, 4G might be removed. It's there for additional informational purposes, but it's not technically required because that information is also covered in Form 2.24. This is one of those instances where we have duplicative answers or duplicative information across the forms, not with intent of confusing people, but because it's an important enough term that we thought it merited having multiple instances where it is stated, once in the document, the purchase and sale agreement, and once in that addendum form that then actually addresses what the buyer compensation is going to be. I see a question in the Q&A, are lenders going to be okay with this? And Brian Purnell, Oregon Real Estate Agency says sale can't depend on the commission. If we write this into the contract, isn't that a violation? We'll get to that. Actually, I've got that in a couple slides for Brian's answer. And then for Barbara's side, are the lenders going to be okay with it? In this instance, it's a question of like for the lending industry itself. Lending industry just sent a message to, I believe it was the court systems in the Supreme Court when as like an amicus brief, or the appeals court as an amicus brief, basically saying if the Sitzer and Burnett trials proceed the way they're going currently, the lending industry has to change drastically in how it addresses the ability to pay a buyer's agent. To answer your question, Barbara, at present, if you got a VA loan, no, you cannot use VA loan money in any way to pay the agent, and the seller really isn't. I suppose if the seller is paying for the buyer's agent independently, then possibly. But the lending industry has to change based on the lawsuits. We'll cover with in a couple slides what kind of how this addresses the code of ethics question and the real estate agency questions. But for present purposes, as far as we are aware, lenders are okay with this, with the rare exception of kind of the hyper specialized federal loans. Those federal loans, they have to just rejigger their process because the world is changing around them. If this is an earnest money agreement, does the brokerage agreement still need to go to escrow, as one training said? Now, Roseanne, when you say the brokerage agreement, do you mean that Form 2.24? Yeah. The way that we've got 2.24 set up is you would send the brokerage agreement over to escrow. So yes, that would still be sent over to escrow. To kind of proceed on that, Form 1.5 is the vacant land purchase and sale agreement. Similar answer, you're still doing the same thing. Is the seller's closing costs covering some portion of the buyer broker compensation? If the answer is yes, then attach form. If the answer is no, proceed. If yes, explain the number. Let's see, I think I saw one other thing in chat that was relevant. We get a recording of this presentation. One of our PBs had a conflict. Yeah, we can send a copy of this presentation out after the training as well. So we'll shoot that out to people afterwards. Rick Harris's statement, not sure why the brokerage agreement is sent over to escrow. We don't do that with the listing agreement. Why not just a demand letter? In this instance, you could just send a demand letter. We've got it set up so that you send the buyer brokerage compensation document so that essentially escrow has the document. It's an instance where if escrow says we didn't need this, it's not harmful to have escrow just have a copy of the brokerage compensation agreement that says here's where the money should go. But to your point, Rick, theoretically, it could be done just with a demand letter. The letter of intent has a similar change to it. So letter of intent is not actually a binding contract. It just essentially establishes the terms that the parties plan to hold themselves to. In this instance, it's added a piece that basically says seller proposes to pay the buyer's brokerage compensation in an amount equal to blank percentage. And so if you are doing a letter of intent, this box, if checked, will represent that the seller is planning to cover a portion of the buyer's broker compensation fee. And that can be something that's essentially negotiated as part of the letter of intent itself. We do get this question periodically about when we've been doing talks about buyer broker or buyer representation agreements. How is it not a violation of the code of ethics? In most cases, this is someone that talks about section or Article 16, Standard Practice 1616, Article 16 states realtors shall not engage in any practice or take any action inconsistent with the exclusive representation or exclusive brokerage relationship agreements that other realtors have with clients. And then the standard of practice 1616 sort of adapts that, or it's a sub definition of that, which says a realtor acting as a sub agent or a buyer's or tenant representative or broker shall not use the terms of an offer to purchase or lease to attempt to modify the listing broker's offer of compensation to sub agents, or the buyer or tenant representative or brokers or nor should they make a submission of an executed offer to a purchase or lease contingent on the listing broker's agreement to modify the offer of compensation. So basically, this entire standard of practice, the entire article is about the exclusive listing agreement, and essentially says, agent, if you're on the buyer's side, you should not make a deal hostage scenario where the modification of a buyer's brokerage commission, a BAC, is a mandatory element of the contract itself. If this was, for example, an agent that said you cannot sign this contract unless the seller's agent offers me a better BAC, a better share of the seller's agent commission, that is a violation of the standard of practice. In this instance, the way that this is drafted, it is not a seller's agent that is paying the buyer's side. This seller's payment of buyer's broker's commission is the seller making a payment to the buyer's broker or on the buyer's behalf in the payment being made to the buyer's broker. So it is not being filtered through the listing brokerage. That in that context, it is not a BAC. It's not even something that attaches to the listing broker's agreement. And so there's the changes, basically a seller offering to pay a buyer's brokerage fee is not the same thing as a buyer's broker forcing a seller's agent to modify the offer of compensation, BAC, in the listing itself. See another Q&A. So basically, if a listing agent enters a 0 in BAC, buyers will need to receive compensation from the buyer. Is that correct? Yeah, sort of. So I'm assuming you said buyer's agent will need to receive compensation from the buyer. In that instance, yes. So if a listing agent enters $0 BAC and the buyer's agent wants to be compensated for a transaction that they're doing, they should have an agreement with their client that says, I am owed X number of dollars for services rendered. If those services rendered, if a BAC is offered, subtract the amount of the BAC from the cost of my services. Essentially, I'm going to throw out random numbers. They have nothing to do with actual compensation. Let's say a broker expects to make $1,000 on a transaction and the seller offers a $500 BAC. In that instance, the broker will receive $500 from the seller's brokerage as a BAC, and then that broker needs to collect $500 from the buyer directly, from their client, to bridge the gap. They were supposed to make 1,000. 1,000 minus 500 leaves you with 500. If the seller side offers $0 on the BAC, that would be $1,000 expected, 0 BAC. Buyer's agent needs to collect $1,000 from their client based on the services rendered. This document is essentially a way for seller to say, hey, buyer, I will cover that $1,000. It's not coming from my listing agent to your broker. It's coming from me to your broker. We'll get back to that when we hit Form 2.24, but for the purposes of just kind of proceeding in the way that we do the library at present, Form 1.9 was modified slightly as well. This is the invitation to escalate. We added a blank space for additional provisions so that you can add additional provisional language to your escalation. This allows you to do somewhat more complex things with your escalation. My caution in this case is be aware when you muddle the mixture, when you change away from kind of the original intent of the document, it does create an inherent kind of fault line in the contract, an inherent risk. And so in this additional provisions section, be very cautious with what you write into as a kind of a custom provision on an invitation to escalate, because you can do things unexpectedly very quickly. You can make it so that the deal is contingent upon something in a way you're not expecting, or that you're making an escalation that is significantly larger than you expected if you write the wrong language in. So additional provisions are now available on the invitation to escalate, but be very cautious with how you use them. We can send a printout of the presentation after the presentation we're done. I'll shoot that over to Katie, and we can get copies of all of the slides sent out to people so that you'll have them after the presentation. So we'll do that afterwards. Form 2.5, this is the repair addendum. It was changed slightly. There was one modification that was made to the form. Specifically, in the signatures section, it now states by selecting accepts in section 7, which is the portion about whether the buyer/seller accepts or rejects the repair addendum. By selecting accepts and signing below before the end of the due diligence period, the parties agree to the terms of the addendum. So what this essentially means is we've added a drop dead date to the repair addendum. If you do not sign the repair addendum if the parties don't agree to it before the end of the due diligence period, this document is not usable to create an agreement on the repairs. Now, if the parties still want to agree to repairs after the end of the due diligence period, you can do that, but it wouldn't be done using the Form 2.5 repair addendum. The reason why this has been done is essentially we have a problem that exists periodically where a seller will counter. A buyer, for example, is starting to do repairs. The buyer says, I want you to fix the roof and the foundation. And the seller says, nope, no, I counter that. I don't want to fix the foundation. I will fix the roof. And so the seller sends a repair addendum back to the buyer. They say, I reject your old repair addendum. Here instead is my repair addendum. I will not repair the foundation, but I will repair the roof. If the buyer doesn't accept that repair addendum until the end of the due diligence period, theoretically the buyer has no more right to request repairs. However, the seller's offer to make repairs, their repair addendum, is a legal offer. And until the seller withdraws it or until a reasonable period of time passes so that a normal party would say that's an expired offer, it's still valid, which means the seller's offer to repair the roof but not the foundation remains valid beyond the end of the due diligence period if you don't have language like this in the contract. This basically means if you're going to be doing repairs, negotiating repairs, get them finished, get them figured out before the end of the due diligence period. It can't be something where due diligence period ends and then the buyer goes, oh no, I forgot to send my counteroffer. Seller, I accept your previous offer. I do want you to repair the roof. Because that's kind of not what the document's intended, and it's not what the parties generally intend either. The due diligence period is the time frame you have to get all of the negotiations and all of the agreements in place. There's a minor modification to Form 2.10. This is the buyer's contingent right to purchase. There's a section in that contract that basically says, buyer, is your property currently listed or is your property going to be listed? The way that it had been written before, it just said buyer is going to use a licensed real estate agent to list it or has already used a licensed real estate agent to list it. There are some buyers that use attorneys to list these things. In some states, that's going to be what they're going to be doing more often than not. So we added a space in there where you can state that the property will be listed by agent or an attorney within a certain number of days. So if there is the situation where an attorney wants to list the property, the form now accommodates that. Minor change, but it's kind of a quality of life thing. This is a new form. It's not the one that people usually want to see at this stage. I know people want to see Form 2.24. That's the one about compensation. But let's talk about this one because it's ordinarily where we're going next. Acknowledgement of receipt, Form 2.23. This document is used essentially to acknowledge that you have had documents delivered by the seller as required in the contract. There are certain portions of the contract that will say something like, seller is supposed to deliver the following documents to buyer. For example, seller, you order your preliminary title report and you deliver that over to the buyer if the title company doesn't send it to the buyer directly. Seller, you're supposed to gather up a whole bunch of documents for your HOA stuff and send it over to the buyer. Those deliveries of the documents, this form is used as a way of acknowledging that the buyer has received the documents that are required. The buyer is going to use this document. They'll basically initial next to the document set they've received, and that is an acknowledgement. Their initials say, I have gotten this document. It is an estoppel at law. What this means is if the buyer initials here, it's really hard for the buyer to say, I never got this document, because you can go back and point to the document, this acknowledgement of receipt, and say, buyer, did you not initial that you had received this document? If you hadn't, why did you initial it? It essentially is a form that creates protection for the seller in that regard. When the seller sends us over and says, buyer, please initial these documents to prove that you've received XYZ. When the buyer initials it, it means the seller can rest easy. They can let out a breath and say, good, I can now guarantee that these documents have been delivered. And if I do need to prove it, this is my proof that I have done my job and delivered the required documents. There are several things that it can refer to: lead documents, notice of completion repairs, property disclosure statement, additional seller representations for certain other documentation, or just other contingencies. You might add something in that has various required documents. For example, you might say seller, needs to prove to buyer that their child has moved out of the house, and give a document showing that the child is living elsewhere. It's a bad example, but there might be some other contingency that happens because real estate is complicated. Does the contingency release cover receipt of documents? So Karen, are you talking about the like Form 2.14 release of contingencies? That one, that can, but it is not the same thing as receipt of documents. Generally, a release is essentially the buyer saying, I no longer am going to utilize a termination right. That's different from a buyer saying, I can't terminate because you've validly done your job. They have the same end impact of the buyer not being able to terminate based on failure of delivery of a document, but it's a different legal concept. So I would say no, it doesn't cover receipt of documents. But if you have a release of like, for example, let's say lead hazard forms are waived. The buyer says, I don't need any of that lead stuff. You don't even need to send it to me. Uh, that release, that waiver form is going to be sufficient. You don't need to send an acknowledgement of receipt because you never needed to send the documents in the first place. If the buyer releases their rights to receiving lead documents partway through the transaction, that release is going to be fine. You don't need an acknowledgement of receipt because the release covers kind of the business end of the transaction. You no longer need to worry that your transaction will be terminated because you have a release of the termination right. The party has given up their ability to end the contract based on that failure delivery or the delivery of a document they don't like. And so in that respect, I would say no. It is, to answer your question, Karen, no. But they're going to serve similar purposes. It's just kind of what the transaction is doing that's going to decide whether you have a release or an acknowledgement of receipt. It's also worth noting the acknowledgement of receipt does not mean that your contract won't be terminated. So, for example, seller is supposed to send buyer various forms about lead hazards. The seller previously did a lead inspection, had a professional come out and do a lead inspection, and they found lead on the property. Seller needs to disclose that to the buyer. The seller needs to send those documents to the buyer. When the seller sends those documents to buyer, the buyer can sign this and say, you are correct. I have received the documents. And then subsequently, within the next 10 days, the buyer might also say, yeah, I don't want to buy this house anymore because it's lead. It's covered in lead, and I don't want a house that could, poison my children or something like that. And so just having an acknowledgement of receipt does not mean that the contract, like the termination right, has been released or removed. Okay. Form 2.24. This is the big one, the seller's payment to buyer's broker addendum. The purpose of the addendum, it's to be used when the seller wishes to pay all or a portion of the compensation that is due to a buyer's broker under a buyer representation agreement. The amount of compensation paid under this agreement will act as a credit against the amount of compensation that buyer owes buyer's agent under a buyer representation agreement. Any compensation paid under this agreement is in addition to compensation owed by seller's agent or seller's agent's firm under a multiple listing service cooperative offer of compensation. So this is not a BAC. This is a separate concept. The BAC and this can work in tandem to pay off a buyer's compensation, the requirement of compensation for services rendered, but they are not the same thing. The buyer will remain responsible for any remaining compensation owed to buyer's broker per the terms of the buyer representation agreement. If this seller's payment to buyer's broker addendum and the BAC is not enough to cover the amount of money the buyer's broker is supposed to be paid, the buyer pays the remainder. Example of $1,000 that is owed to buyer's broker. This seller offers to pay $250. Seller's agent has a BAC of $500, $250 plus $500. Seller's agent and seller together pay $750 to the buyer's broker. That leaves $250 that the buyer personally will be paying per the buyer's representation agreement. So this is not something that just replaces BACs. It is a document that is used as kind of another way of paying a buyer's broker compensation from the seller's side. Now note, the seller is not obligated by law or by any other means to provide compensation to a buyer's broker, and the amount of a rate of real estate compensation offered is not fixed by law or by any other means. So sellers, you don't have to sign this, is the answer. If the seller doesn't want to offer payment to the buyer's broker, the seller doesn't have to. That is kind of the core of this. If the seller would like to offer compensation to the buyer's side, then that's lovely, but they don't have to. The buyer's representation agreement, section 4. The buyer has, it's a representation that buyer has entered into a written agreement to compensate buyer's broker for the purchase of property. The buyer is going to attach that document to this 2.24 or provide a copy of that written agreement to compensate buyer's broker. Essentially, buyer, you should have a buyer's broker agreement with your client if you're going to be asking the seller to pay your broker. Because if you're supposed to be paying your broker, the seller needs to know how much you were supposed to be paying your broker. It is possible that a seller will offer more than the buyer is offering the buyer's agent. It's unlikely. The reason why the buyer attaches this document, why the buyer attaches their buyer-broker agreement, is so that the seller can essentially double-check and make sure that they are not overpaying. There's no windfall happening where the buyer's broker is getting paid $6,000 when the buyer was only going to pay them $1,000. That's not what this agreement is about. This is a way of having the seller waylay costs for a buyer. You'll put in the name of the buyer's broker, the buyer's agent, the firm, the address, the license numbers, and all that. And then we'll talk about compensation to the seller side. So no windfalls for buyer. The seller's offer of compensation down here at the section 6. By signing the addendum, the seller is agreeing to pay the buyer's broker firm a percentage price or flat value upon completion of the transaction, in addition to any amount that will be paid by seller's agent or seller's agent's firm to the buyer's agent under a cooperative offer of compensation. It is in addition to the cooperative BAC. Seller's agent to pay buyer's broker firm, agreement to pay buyer's broker firm will not establish an agency relationship between seller and buyer's broker. See some stuff in chat. So if receiving a BAC, we don't need this form. Is that correct? Yes. Well, most of the time. If you are receiving a BAC that covers the entirety of a buyer's commission, or the buyer's agent's commission, then there's no need for the seller to pay the buyer's broker at all. Essentially, if the BAC covers the entirety of the buyer's broker commission, then the seller has no real incentive or reason to pay the buyer's broker commission. And in that case, there wouldn't even be a payment of the buyer's broker's commission because the seller has nothing to pay. The buyer has already, the agent has been compensated. So if you are receiving a BAC that is equal to what you're expecting to make in the transaction, your broker compensation from your representation agreement, then yes. So this compensation is in addition to fees agreed to in the MLS. Yes. So what I mean is if the buyer representation agreement has 2.5%, but the seller's offering 3%. Yeah. So if the buyer representation agreement offers 2.5%, but the seller is offering 3%, at that point, the seller can agree to pay a larger number than the buyer representation agreement covers. It's essentially the seller offering money to the buyer's side, saying, here is money, make use of it on your broker. And if that's the case, and the seller is offering they had a great experience with the buyer's broker, for example, then theoretically a seller could offer a higher number. Do we expect that to happen? Almost never. No. Is it something where we're encouraging brokers to try and like sneakily add a higher number or get a seller to pay him extra money? No. But that's essentially what this process is. Can you please do a class for us principal brokers so we can go deeper into these commission changes? I'm getting a bit lost here. Yes, into the future, we can do a class for principal brokers into the commission changes. The premise of this essentially as a flat standard is a buyer's side is entitled to a certain amount of commission for services rendered. If you have a buyer's representation agreement, the services that are rendered will be paid for by the buyer if no one else pays for it. That's what a buyer's representation does in large part. Not all it does, but a huge portion of what it does. A large part of the buyer representation agreement is basically a statement that says, buyer, when I finish providing services to you, the following services that we've all agreed to do, you will pay me X amount for the services I have rendered. And if no one else is going to pay for it, you personally will pay for it, buyer. Now, how do other people pay for it? That's what the BAC is. The BAC is the seller's agent saying, I will pay X amount of money to the buyer's side, subtract it from the amount the buyer is owed. This document is the seller, not the seller's agent, saying, I will pay the amount you owe your agent, buyer. It's if you were to imagine it a different direction, it would be like the seller handing a wad of money to the buyer and saying, you know, like your grandma giving you a Christmas card with some money in it and saying, make sure you use this on your school books. You use it on your school books because that's what you were asked to do. Now, if the school books aren't expensive enough, you have extra money that has been handed to you by your grandma. That's what this does. It's the Christmas card that transfers money over to the other party. That is not the same thing as a BAC, though. See a comment, this is going to erode buyer broker commissions because the seller is going to say what they would have taken 2.5%. The buyer is going to say, I want the extra 0.5%. If the buyer's representation agreement establishes the buyer being paid 2.5%, the buyer's agent should not be expecting 3%. Using your earlier example that you put in the chat, if the buyer's representation agreement says 2.5% is what the buyer's agent is being offered, the expectation is if the seller is going to pay for that buyer's agent, they're not going to pay extra. In that context, I'm not quite certain where the erosion of a buyer broker commission comes from. So from there, the other portions of this are authorization and payment. The parties do authorize and instruct escrow to disperse the seller's offer of compensation. This is essentially where we do say that this document gets sent over to escrow because it does end up operating as a modification to escrow instructions because it's changing where the money is dispersed. In that context, both parties do need to authorize this modification to the dispersal through escrow. After accepting this addendum, the parties cannot modify the amount unless there is some sort of an agreement that happens between all three of the involved parties. This is an agreement between buyer and seller, but also an agreement between buyer and buyer's broker and seller and buyer's broker. The seller's agent is not technically a party to this. They're not a signatory like a legal party to this transaction, this document. This is between buyer's broker and the parties to the actual purchase and sale itself. The buyer's broker does need to consent to this because they are essentially it's them agreeing to receive payment from someone that is not their client. Let's see. I see in chat. So buyer's compensation agreement is a conditional agreement. It's not covered by the seller. Then buyer pays buyer's agreement. Buyer pays buyer's agreement. Yes, the buyer's compensation agreement is a conditional agreement. If it is not covered by the seller, then the buyer will pay the buyer's agent. I would like to note that the numbers we are using in chat have nothing to do with us establishing. They are simply for mathematical purposes. I'm going to just use pure math on these. If the seller is offering 3% on the MLS, does that not supersede the BAC at 2.5? This 2.24 is a non-issue. If the seller is offering 3% on the MLS, that supersedes the BAC at so seller's offering 3% on the MLS as their BAC, then this 2.24 would essentially be a non-issue. You are correct on that one, Jason. Can you tell us which, if any, of the forms are mandatory to use during a transaction? This form is not mandatory to use in a transaction. The mandatory forms to use in a transaction would generally be the purchase and sale agreement, and then depends on what the property does itself. So, for example, if you have a well on the property, then the well addendum is going to be a mandatory document in that transaction. As a baseline, though, the only mandatory document in any transaction is going to be the purchase and sale agreement itself, which usually has to be there. Between agents and clients, typically you're going to have a listing agreement is mandatory between seller and seller's agent. It's not technically required, but we're going to say for the purposes of law, yes, you need a listing agreement. And on the buyer's side, we would generally say if you're going to be requesting actual payment of compensation for services rendered and you want that established, a buyer's representation agreement is mandatory. Everything beyond it is going to be context specific for when the form is required. Oh, in the context of fees to brokers, uh, so in the context of fees to brokers, if you have I'm going to lay out scenario. Buyer's agent is working for buyer. Buyer is paying buyer's agent, and all parties are happy with this. The only document required is the buyer broker agreement because the buyer is paying their agent. If the buyer doesn't want to pay their agent and would prefer that the seller pays the agent, this form would be a required form in the context of that fee being paid for the buyer's broker. If you're in the context of a BAC and the buyer doesn't want to pay their agent, but the seller's agent is willing to portion out part of the seller's agent's take in that transaction to pay a buyer's broker for services rendered, in that case, the BAC, the buyer's or broker compensation agreements would be required because you need to establish, which is built through the listing agreement. So this is only required if you have a situation where the buyer does not wish to pay their agent the full price, or the seller wishes to pay the buyer's agent for a portion that the buyer does not want to pay. For example, a distressed buyer who says, I would love to buy your house. I can't offer a high enough number because I have to pay my agent. Now, if you can pay my agent, then I can offer the number I'm putting on this house. How the lenders are going to interpret that is largely based on kind of the context itself. I'm not advising like mortgage fraud in this case. I think there are many terms in the buyer representation agreement that shouldn't be shared with the seller or their agent. This form confuses me. A class would be good. Yeah, that's a fair point, Rosanna. I'll credit to that one, and that's something to take into consideration on this. If a seller agrees to pay the buyer's compensation via a listing agreement as cooperative compensation, is the buyer still required to submit a BAC? So the cooperative compensation is the BAC. That has been my understanding of the term, and that's why I've been bandying it around. The cooperative compensation offer from listing agents off brokerage to pay a buyer's brokerage is BAC, cooperative compensation, the buyer broker commission or compensation. All of those terms have been used kind of interchangeably in the industry, and they all mean roughly the same thing. So if a seller is agreeing to provide, a seller's agent and seller both agree to provide cooperative compensation, the buyer doesn't need this form unless that cooperative compensation offer is insufficient to cover the buyer's required costs. If the buyer is distressed or doesn't have enough money, or if the buyer just doesn't want to spend the money on that, and they say, look, seller, there's a better house that I want to buy, and I'm going to buy the other house because it's going to cost me less. But why would I ever, you could also offer to pay my agent, and then I might consider putting an offer on your house. And if the seller says, great, I would love to do that because it's a distressed market and sellers are in trouble right now and I need someone to buy it. At that point, it makes sense for a seller to offer to pay the buyer's broker commission, even if the seller's brokerage is not covering it with a BAC. That's when this form is utilized. So Frank, to your point, the reason why this form is utilized is based on Sitzer and Burnett. It is more likely into the future that you're going to see offers of 0 BAC on an MLS. If that is the case, and there is a 0 offer of BAC on the MLS, and the buyer basically says, I can't afford to pay my agent in this transaction, this form is a way of establishing payment from the seller to the buyer's broker that does not come through the MLS or come through essentially the cooperative compensation model of payment. How do we notate that the offered BAC in the listing is paid by seller without needing the form 2.24? So if you have a cooperative compensation, I'm going to throw out numbers. I know they're going to sound like I'm using abstract ones, but let's just use them. They're not establishing commission. Let's say a seller's agent expects to make 4% on a transaction. They are offering 2% as a buyer's cooperative commission. What that means is if there is no buyer's broker and the seller helps sell that house to an unrepresented buyer, the seller makes 4% in that transaction. That's what that represents. That's the buyer broker commission without a cooperation in that instance. So the seller's agent, when they put in, I'm making 4%, offering 2% as cooperative, what that means is if there's no buyer's agent, the seller's agent, the resulting outcome is the seller's agent takes the full pot 4%. When there is an offer of a cooperative compensation, that money doesn't come from the seller. The seller pays the agent, and well, the old way of doing it was the seller pays the agent pays the buyer's broker. Now it's all done through escrow, but essentially it's saying, seller, you were supposed to get 4, but there's a cooperating agent. So we're going to take that 4 and split it in half, and 2 is going to both the buyer's side and 2 is going to the seller's side. That is the BAC. It's not paid by the seller technically, it's theoretically a splitting of the amount owed to the listing agent. That's why it's a cooperative compensation. If that's the case, 2.24 is not used because the seller is not paying that portion. Now, if you want the seller to be the one paying the buyer's commission, that's when this form is involved, if there is no offer of compensation for cooperation. Questions, maybe questions after the presentation. That's we'll get to that at the end, I think is a good point there, John. This isn't how WVMLS listing contract reads anymore. Listing side gets X%, buyer side gets Y%, and the Y can't go to the listing side. We can address WVMLS at the end of the presentation. I don't have the form in front of me, so I can't actually speak to it exactly. If the buyer broker and the buyer agree to reduce the buyer compensation to match the seller's offered BAC, is there a specific form that should be used for updating the buyer broker agreement? You would use form 9.9. That's essentially it's the agency. Well, assuming you're using Oregon Realtors forms, you'd use 9.9, which is an agency addendum. The way to update that would basically be you would just amend your buyer broker agreement. Questions in chat as well. As an agent, I submit the offer. The seller does not agree to the bridging of the gap for the buyer. Doesn't want to pay anything, doesn't have the money. Seller agrees to the contract. Where does the buyer agent go? If you're an agent and you submit an offer and the seller does not agree to bridge the gap for the buyer, at that point, the buyer, if you have a buyer representation agreement, which is why we're being bullish about why you should have buyer representation agreements, the buyer is the one that pays the remaining amount. If the buyer doesn't have the money, let's say, for example, you have a buyer that hires you and says, I am going to pay you, agent, $5,000 for your services. And when it comes down to it and the buyer says, I want to offer $100,000 on that property, sorry, buyer agent, I don't have enough money to pay you after I put $100,000 on that property. That's a huge problem, and that's kind of a problem of the contracting itself. That's essentially someone that is putting an offer down that is more money than they should be putting down. There is no legal answer for how you can kind of stop a buyer from essentially making a bad choice with their money. The point of the buyer representation agreement is that you then have the ability to say, I am entitled to X amount of money. If the seller is not willing to pay it and the buyer doesn't have enough money to pay it, that's a problem, and there's no good way of addressing that, which is part of the reason why Sitzer and Burnett our hope is shot down at the antitrust level, at like the national or the appellate level, because this is essentially the problem of a buyer saying $100,000 and then going, I don't have money to pay my agent after I buy a house for $100,000. That means the agents, the buyer's side, is left high and dry. The buyer's representation agreement gives you something to use to try and pull back money in that case, Jason, but that is if a buyer is offering more money than they have and they also don't have enough money to pay their agent, that's a problem. Are we jeopardizing ourselves as listing agents by paying a BAC? Not inherently would be the answer to that. A BAC is not necessarily a risk or a jeopardization. It's a model of payment structure that has reasons for it. Is this a form you would use when representing a buyer on a purchase on a for sale by owner? No, in that instance, if it was for sale by owner, we have a non-represented seller, a non-agency agreement. That's, I believe it's form 9.4. It might be 9.5. I don't remember the number exactly. But that non-agency agreement is the one that basically says, I'm a buyer's agent. Seller, you're a for sale by owner seller. I have to be paid for the services rendered and the payment comes from you. So please sign this non-agency agreement, which then says, I'm not your agent, but payment will come from you. And so there's a different document for that situation, Steve, to answer your question in the Q&A there. If the buyer doesn't have the funds and the seller won't pay the commission through an agent, do you have the right to walk away from the offer just submitted? That is something that has not actually been determined in a court of law, so I don't have a great answer for you, from like a really solid answer. The expectation in this instance is, for example, if you knew that your buyer was unable to pay you for the services rendered and yet was offering an amount that then distressed the buyer's finances to the point where they can't pay you, I would say my understanding is you would have a very good argument for why you would be able to walk away from that offer without violating the code of ethics or violating the rules of real estate, because essentially you're not working for free. And the simple right of an agent to say, I don't work for free, is not it's not illegal for you to say that. So to answer your question in chat there, Christy, I believe you would be able to, but we have no law to back that up yet. And then there was a question in chat. I thought this whole lawsuit on the East Coast is the inflation of house values because BAC was being included. We'll get to that at the end. I can talk about the lawsuits at the end of this presentation if need be. And then I'll address the Q&As afterwards, but I'm gonna keep going through the presentation because we need to get to some stuff. So money comes out of escrow. You need to tell escrow about it. So that's why we do say you need to send this over to escrow, because theoretically it could be a demand letter, but you just need to get instructions to escrow. If parties do want to change the amount, you need to get everyone's approval. Buyer broker is a part of this transaction, this agreement, this three-way transaction. So the buyer's broker would need to consent to modifications. If they say, actually, I'm paying the buyer's broker half what I was going to pay them, we need everybody to be online because there was an agreement signed earlier. There were minor modifications to the seller's agricultural land disclosure, specifically the way that it was section F4 was written. It stated beforehand, have all or any portion of the water right been utilized during the past 5 years, which was nice, but not super helpful. The only, all that basically meant is if you said no, all or any portion of the water right has not been utilized in the last 5 years, all you would be able to tell the buyer at that point is, I don't have any water rights anymore. Instead, by writing it this way, have all of the water rights been utilized annually during the past 5 successive years, we have the ability to say, if you say no to this question, then the buyer should inquire more deeply into it because there's a chance that some of the water rights have been lost, but not all of them. So rejiggering of the language on that. Similar answer change to the vacant land disclosure, just to kind of address the way that Oregon does water law and water rights. Form 4.2, this is a statement of explanation. The statement of explanation is a new document. It is, oops. There we go. Sorry, there we go. Tell me in chat, you see 4.2a. I accidentally pushed a button I probably wasn't supposed to, and 4.2, okay, we're back on track. 4.2a, statement of explanation. So the use of this form, 4.2a, is designed to be an attachment, kind of a sister document to the investment property addendum. It obligates the seller to provide additional disclosure documents, but if there's an instance where the seller can't actually provide the document, they're supposed to provide a statement of explanation. So essentially it says, seller, give me all the documents I ask you for. If you can't give me the documents, tell me why you can't give them to me. This is a document that helps you tell them why. You can also request an extension to the disclosure period. So if the seller says, I can't get you the documents yet, I need an extra 6 days, they can use this to essentially extend the additional disclosure period. If you don't have any requirement, if this box is not checked, it can just be a statement of explanation. It's just a statement. And then at the very tail end here, if there's a if section 4 has a little checkbox on it, we do need signatures of the parties because we are modifying the contract by basically adding more time frames to something. If there is no modification to the additional disclosures, it's just a notice. It doesn't need signatures from either party technically. So as we were saying, sometimes you need more time and you can get that. You provide your statement of explanation. If parties are extending their time frames, you do need to sign because you're modifying the contract. Otherwise, it's just a statement and it's a notice essentially. There was a slight modification to the termination document. We added 2 sections in, well, modified 1 section and added another one to address changes that happened in August of 2023. Essentially, there was an update to the manufactured home and the marina part, the manufactured home and floating home agreement that addresses situations where the landlord doesn't approve a buyer's application for tenancy. We changed the timeline on when buyer's landlord approval needed to happen. And then there was also a section according that was whether the buyer has received a notice of substantial rent increase. If the rent went up a lot, the buyer might not want to buy anymore. And no, those are rights to terminate that were built into the contract. So we have check boxes for those now. The corollary for the seller's notice of termination is also there. So slight modification to address the updates to Form 1.3. There was also a very minor update to the deed of trust. It now says buyer/grantor and seller/beneficiary to better identify the parties, because the rest of the contract talks about the grantor and the beneficiary rather than the buyer and the seller. That was a request from title just to make it easier for title to kind of administer these documents. And so those changes have been made to basically clarify defined names and terms. The listing agreement has a handful of changes to them. Before I get into listing, I'm going to check the chat again. And the Q&As to see what we've got. Wouldn't it be a problem if the listing agent tells the seller agents won't show you the property if you don't offer BAC? Yeah, that it would be a problem if the listing agent explained to their seller that they needed to have a BAC because otherwise the property wouldn't be shown. But if there's some sort of a statistical explanation or a statement where you can say basically like, look, seller, sometimes buyers aren't going to be able to purchase your property at the price you're asking because they also have to pay their agents. And if that's the case, if we offer a BAC, the buyer has to pay their agent is not a distress point. That could mean that you will have more offers on your property if you have an offer of a BAC. Now, that doesn't mean that agents won't show your property. It's possible that the agents will show your property even if you don't offer a BAC. So I would say an anonymous attendee in the Q&A, you are correct. It would be a problem if the listing agent said literally agents won't look at your property if you don't offer a BAC. If the buyer, another Q&A is, if the buyer initially agrees to pay BAC and the seller declines to pay BAC, can the buyer decide that they don't want to proceed with the purchase? Basically, can an offer be contingent on a seller paying the BAC? If the buyer initially is like sends in an offer that says, seller, you're going to be paying my agent, and the seller says no, you don't have a transaction going on anymore. It can be a term that the buyer requests as part of the offer that the buyer makes. So if the buyer's offer includes, seller, you got to pay my agent, and the seller says, no, I don't want to pay your agent, then you just don't have a contract that was signed. You don't have a transaction at that point. And then we kind of got to that one. Can you terminate agency relationship if the buyer cannot pay your buyer's broker commission? To a certain extent, that's never been tested as far as I'm aware in the law. But based on how most of the other agency law and employment law works, if you have a client that hires you for services and then at the end of the contract can't pay you, you generally have a right to have gotten out of that contract as soon as you find out you can't get paid, as well as generally a right to compensation for services rendered. You're not just someone that gets strung along and then you find out afterwards if you get paid or not. You are a worker that does a job for someone, and so that as far as I am aware, you would be able to get out of the agency relationship upon learning that the buyer cannot pay you for the services you are rendering. Listing agreement, several changes. So we've made some changes to the listing agreement. The first 3 chunks are the same. They haven't changed. So the top quarter of the document stays exactly the same as it's always been. No modification there. From there are some changes. So for example, we do have a section in the term that does talk about if the agreement terminates, the seller remains obligated based on section 7 below, so the brokerage fee, which has if you terminate the contract, seller sells to someone that the agent placed in contact with them, so kind of a procuring cause after termination, that's built into the term itself. The seller remains obligated to make those payments. There's more language about the brokerage fee being negotiated. It's not a pre-established number. Our advice as a baseline is you should not pre-print in a number for your compensation. That's ill-advised to just have that number pre-printed. The brokerage fee is a fee for services. This is what's written in there. Fee for services rendered, established by the parties to this agreement. It is not fixed. It is not controlled. It is not recommended by law or by MLS or any other person that is not a party to this agreement. Now, Just because it's negotiable doesn't mean you have to just accept, like, eat crow and eat zero, have a $0 transaction. Negotiable doesn't mean you are valueless. And we want to reiterate that just because a fee is negotiable, that doesn't mean you're required to change a brokerage fee when the client requests it. You can't be halfway into a transaction and a seller says, "Well, didn't you see the contract? Brokerage fee is negotiable. I don't want to pay you anymore." That's just not how it works. But it does mean that if the seller says, "Well, yeah, I want to hire you, but this is going to be an easy job, so I don't think I want to pay the full amount," then you have a negotiation that's going on over what the value of your services are, and you should know what your services are worth. This section down here, the brokerage fee shall be negotiable through the term of the agreement. Brokerage fee will be paid by the firm at closing the sale, and that's largely the same as it's been before. Please slow down. I will slow down again. Hypothetical situation in the Q&A. Agent has a family member buyer who wants to buy a house. Agent tells family member buyer that they are happy to assist at no charge. Family member buyer finds a house, an offer is written. If the house is listed and has a contract to share commission between seller and buyer's agent, can the buyer's agent ask the seller and the seller's firm to waive or forego the buyer's agent commission? The end result is the seller nets higher amounts of closing funds. Cynthia, I'll address that one after the presentation. That one's kind of a stringy hypothetical. I'll have to look at a little more deeply. But the baseline for this section is essentially we've integrated several sections. This is largely based on what Michigan is doing, where we've said this is a negotiable fee. Be aware it is negotiable. It is something where if you do believe that your agent is, the amount they're asking is too high, seller, you can push and say, I don't think that's what it should be. An agent, if your client says, I don't think I should pay you this amount, you should be allowed to push back and say, actually, I am worth that amount, and here's why. We added some guardrails on the actual cooperative broker fee section. So if the box is checked and a cooperative broker takes part in the sale, the PB is going to pay the cooperating broker an amount equal to a percentage of the sales price or a flat fee. This is the cooperative broker compensation. So if you check that box in your listing agreement, that's an indicator that you are offering a BAC. We also provide this section if no cooperating broker fee is offered or if the cooperating broker fee is less than the total value of the cooperating broker's expected compensation from a buyer's representation agreement, the buyer may request seller to pay the buyer's broker fees as a contribution to buyer's closing costs. So a reiteration of how the sales agreement language works. Essentially, if the amount you're offering is a BAC, or if the amount that or if you're not offering a BAC, and that's just not enough to cover what the buyer's representation agreement covers, you may have a buyer that requests that you pay stuff. You're not obligated to pay for the buyer's agent, but be aware that's something that could happen. And lastly, we added some guardrails around checkboxes around what you do when the buyer forfeits earnest money. So if there is a termination that occurs throughout a transaction and for whatever reason the buyer forfeits their earnest money, is that something that gets paid halfway towards the brokerage fee, or is that something where the buyer forfeits the earnest money and all of it goes to the seller? Check your box to address which one you're doing. So that's the changes to the listing agreement. Not substantial changes, mostly just reiterations that the listing, the compensation is negotiable, and that compensation is to a buyer's side from the paying from seller's side to the buyer's side. It's not required. It's something that can be done, but it's not required. For the seller's non-agency and fee agreement, to answer the question from earlier, Form 9.6, that's the one you use when you've got a seller's agent that is for sale by owner. We removed buyer's initials that were still at the bottom of the form. It's a document between the seller and the buyer's agent. The buyer doesn't need to initial it, and so those initials were accidentally left on the form. And this is a good time to note that every single one of the documents in the footer, it's been updated to say 2024-1. So you know which edition you're dealing with. It'll say 2024-1. Now our copyright is still 2023. That's when we have filed our copyright, but the version numbering is different. Form 9.10 is a new document. This is the buyer broker compensation agreement. This is the BAC, the buyer broker compensation agreement. This is how you establish seller's agent brokerage paying buyer's agent brokerage as part of the like through the listing, essentially, through the MLS. It establishes the terms of compensation between a listing firm and a buyer's agent's firm. It is a memorandum to explain the BAC agreement that existed in your MLS. The MLS is not an agreement. It's a statement. It's an advertisement. This is an agreement. That's the difference between those two. Just because the MLS says things doesn't necessarily mean that it is a guaranteed lock-in in a court of law. If you have an actual agreement signed by the parties evidencing actual agreement between the two parties, you now have something that is more strongly it can be more strongly upheld in a court of law. We go on to basically explain why this document is used or why it's necessary, and that's based on ORS 696-290, which states that a buyer's agent may not accept compensation from anyone other than their own principal broker that they're associated with, and a listing agent's principal broker can't make payments to the buyer's agent directly except through the PB. So based on 696-290 subsection 2 and subsection 3, we have to have an agreement or some sort of a process in place where the listing agent pays the buyer's agent's principal broker, and then that brokerage disperses money to the agent according to that compensation or the independent contractor agreement of that brokerage. We specify the names of the parties, and then we go into the actual agreement itself. In exchange for buyer's agent assisting the buyer's client with all professional real estate activities related to the sales agreement, the parties agree that the listing agent's principal broker shall either directly pay or cause them to be paid out of escrow a certain amount upon successful close of the sales agreement. Now, that second box should probably be the one that's checked most of the time. I'm not aware if the direct payments are as commonplace these days, but you usually want the second box checked. It's going to be an escrow process. You're going to explain precisely, you'll have a little section for instructions. You'll explain precisely how this buyer's broker commission transaction is going to work. If there are additional instructions, specify them. And then you'll have the escrow company's title officer number. And this is essentially, it's not controlling, the controlling document section is in the event that it does not reflect the amount of compensation offered in an MLS or in any other previous advertisement of compensation, this agreement controls. This is the ultimate agreement between the parties. So if, for example, your MLS said we're offering 2.5, but after some wheeling and dealing, the buyer accepts 2, then this document that says I will get 2 is the controlling document, even though the MLS said 2.5. Why is that the case? Because an MLS is an advertisement. The listing is an advertisement. It's not an agreement between the parties. The agreement is what matters. When you have a mutual acceptance of terms between two parties on those specific terms, then it is binding at law. It is an agreement between the brokerages. It is not an agreement for the client to sign or even to review or look at. This is between the buyer's agent brokerage and the seller's agent brokerage. They technically don't need to know any, the seller needs to know if a BAC is offered. That's handled through the listing. This is an agreement between the two brokerages. It is essentially a memorandum that explains that you are entitled to the certain amount as promised in the listing. And this sets those terms into stone because the parties have signed it on the dotted line. A similar version of this is for buyer-broker referrals, or rather broker referrals in general. The referral agreement follows much the same process, procedure, and structure as the previous Form 9.10, but this one is in reference to referrals. This one, the description of the agreement is the referring agent is currently engaged by a client or has been approached by client for the purposes of purchasing or selling a property. This broker referral agreement is between the referring agent or their firm and the receiving agent and their firm. The agent agreement is related to the receiving agent paying a sum of money to the referring agent for the referral of the client to the receiving agent. Basically, you had a client you can't work with. You tell them, client, go work with my friend Jake. Your friend Jake says, I will pay you a little bit of money as a thank you for sending client over to me. That's what this document does. It's the same ORS 696-290 problem where the principal broker of the receiving agent can't directly pay the referring agent. You have to pay their PB. And so this puts into writing essentially the agreement between the brokerages for that referral. Same concept, same process. You have the names of the parties. You specify the agreement in exchange for referring client to receiving broker. Receiving agent's principal broker shall either pay directly or cause them to be paid out of escrow a certain amount upon successful closing of the transaction, and other specific instructions. Again, this is between the agents. It's not with the clients. If you are referring a client out to another agent, that's between the brokerages. It has nothing to do with the client who is being referred. Technically, this is an agreement between the brokerages. Lastly, we made some updates to the advisories. Specifically, we added a process in there for offers of buyer compensation. Essentially, this is Form 2.24, the process that goes into that. When a buyer requests that a seller pay a portion of the buyer's agent commission, the process for what it looks like is now in the advisories, in both of the advisories. Same language in both. And we updated the titling to the non-customary documents and real estate love letters section to reflect that it does have a fair amount of information in it about fair housing. It's essentially a fair housing advisory. Why we didn't say fair housing, non-customary documents, all that the first time, I don't have a good answer for you, but it now says fair housing. So if you're wondering where the fair housing language is in the advisories, right there. And before we get into the form clause library, I'm going to go through the Q&A again. So what do we have? Cynthia, I'll do your hypothetical after the fact, but let's see what we got. Does an agent have the right not to take a listing with a 0 BAC? If not, how does that differ from not taking an overpriced listing? It's a fine question, Roseanne. And I'm doing this right off the dome, so I might be wrong on this, but I'm relatively confident. I don't believe there is anything inherently wrong with an agent saying, look, client, if you're not offering a BAC, I can't work here because I have a reputation or I have whatever the other reasons are. I'd have to look over the code of ethics to see exactly if that's the right answer. It's very possible that I'm not correct on that, but I believe to answer your question in that case, it would be roughly the same as not taking an overpriced listing. I would treat that as similar as an option. Cindy says, why isn't there an option for a no termination fee? Cindy, let's see, what were we talking about in that case? So the termination fee, you can put $0 into the termination fee on any of the documents that talks about it. There's a section that's going to talk about a termination fee, and if you put $0 in, then there's actually no termination fee. But you do have to very intentionally write in $0, or I guess leave it blank. Why is escrow on the form, since it is that is not determined until there is a purchase agreement? Randy, is that for the referrals and things like that? If that is the case, referrals and the buyer broker thing, if that's the case, then escrow is on the form as the way of essentially you would fill that out and put escrow in if you have it. If you don't have it, then theoretically you wouldn't put in any of the escrow information. I might want to put in a percentage amount on Form 9.11. That is a good point, Roseanne. We weren't actually certain if brokers did referrals for a percentage of the purchase price. Our understanding was it was just a flat number, but if it is a percentage value, that can be added to the form. Yeah, so Cindy, to answer the question, based on in the listing agreement, there is no terminate. You can offer $0 on a termination fee, an early termination fee, that you can put $0 in on that. Now, if your zip forms or your SkySlope doesn't let you put $0 in, or please let us know, because that's something that we need to tell them to modify the programming on that document. But you should be allowed to put $0 in. That's something that we have that was in our express requests for the documents and the spaces to input data. I see something in chat. Might need to talk to your principal broker on BAC, what they want you to do. Okay, so form clause library. The form clause library is the last thing we'll cover here. The clause library is a tool to assist you in drafting accurate language for your general addendums. It requires membership in Oregon Realtors. Associate membership technically gets you in there as well. Basically, you need one of those M1 numbers to be able to get into the website to utilize it. We'll also set it up so that there's a link through orforms.org, but it'll always require the same login through with your Realtor ID, your membership ID. It is not a replacement for good editing or clear thinking. It's not a replacement for good drafting. It is simply a way to create more consistency and legal foundation in the general addendums you put into your contracts. The way it works is we're going to have this giant section on the website with various boxes that you can click the read more button on. It begins by saying select the type of form you are seeking to create from the below options. The drop-down menu will provide a link to the clause creation page that will assist you in creating your desired form. So let's say we're doing buyer is using contingent funds. I click read more and it drops down. The Oregon Realtors purchase and sale agreements require disclosure if the buyer is making use of contingent funds. That is funds that are based on a future happening that is oftentimes out of buyer's control. For example, a holiday bonus. The buyer must notify the seller if that's the case. This provision can be used to provide that required notice. And then there's a link. If you click that website link, that little button right there, it takes you to this. A web page that basically says the exact same information about usage, and then it's got a checkbox which says, I understand that this is a tool for my use in the transactions, but all the clauses I'm creating are the result of my inputs. By checking this box, I'm indemnifying Oregon Realtors from liability or responsibility for errors or omissions in the clause or loss and damages that is incurred as a result of use of the clause. You are expected to review and edit anything that you put in these clauses before you utilize it in your forms or your transactions. Essentially, we're saying, because we can't control the end result, and this is pretty flexible, this is our indemnity provision. You check the box, and then it opens up the rest of the clause to fill in. You'll start by putting in your email address. Here I've got mine. And then you'll fill out the rest of the clause itself. You'll note, for example, in this instance, it's buyers making use of the contingent funds in the following amounts for, and then you'll choose what it is. Is it for the purpose of paying a down payment? Is it for the purpose of paying closing costs? Is it for the remainder of the purchase price? And then I'd say it says this addendum shall operate as the buyers providing a proof of funds for the contingent funds. If there is a failure of the contingent funds or a change in the availability of the contingent funds or a change in the value of the contingent funds such that they are no longer sufficient to complete the original purpose, they'll notify them. This is a restatement of stuff that is in the purchase and sale agreement. If I were to check a box here, it'll open up other things that I can choose. How much is the amount of the contingent fund being used here? I'm going to say $5,000. What is it, the contingent fund that's being used? In this case, it's a gift for my parents. Great. So I'll check out that it's going to be used for the down payment. I'm going to do the amount. I'm going to do the description, and then I'll click the submit button. Then I get email. It'll say, thank you for using the clause library. A copy of your clause will be emailed to you at the address you entered. And on your email, you'll get this document. Thank you for using the clause library. Please copy the below text and paste it in your general addendum, then review and edit the clause language as necessary. And you would copy and paste that language below into your general addendum. It basically has all of the inputs you put in, as well as the generic language of the clause itself. And so by doing this, there are, I believe there's about 35 or 40 separate clauses in the clause library that can be utilized, and they're modular in that regard. So based on what you input, it'll change the rest of the inputs, and then that'll change what email you get sent to you. And that's all I've got. That's the whole thing. This one went over long, and I apologize. There were questions, a goodly number of questions here. And with that, I do release you back to the wilderness.